Hello, everybody. Welcome back to the Henry YouTube channel. You might remember a couple weeks ago, I made a video in which I told everybody that I had been ordered to court to explain why I shouldn't be held in contempt of court. At that court hearing, a lot of people attended it. We had about almost a dozen people there, and we all went out to eat afterwards. We had a great day. But after that court hearing, it had ultimately gotten continued for 15 days. The court had allowed me time to look for some legal representation. In the interim, a few things happened. I want to get right to the point. That contempt of court case has now been dismissed. There's a lot of speculation going on around the internet, people saying that I would be in jail, or people saying that I was sure to go to jail, and ultimately that didn't happen. So those people's credibility should be in the toilet right now. But of course it won't be. But anyways, back to my initial point. I'm going to tell you a few things that happened in the interim. How did this case get from an active case to dismissed? And I don't want to leave y'all hanging because I was pro se in this. So if anybody is thinking about going pro se, if anybody's thinking about going out with the bar, maybe you want to listen to this and get some advice. So my first thing that I did in that was I filed a motion for discovery. So the contempt of court charge, they were saying that I aided and abetted, or that I did record in a courtroom and then that I published it, and that these actions were all done contrary to a court order. Now, since the case is over, I can speak about it. There was no court order ever issued at the times in question, right? Nobody had ever told us, a judge or an officer of the court, nobody had ever told us, hey, look, you're not allowed to record in here. So ultimately, no order applied to us. Right. And of course, the local rules, I mean, I'm just a layman. I can't be expected to know all of these obscure court rules. So that was going to be a good defense for me on the whole. But when I went to court on the first, I went in there and I told them that I think that my constitutional rights are being violated. And then I advised them of Section 18 or Title 18, Section 242, the United States Code, which makes it a crime to deprive somebody of their rights under the color of law. Now, they weren't too happy to hear about that. But after that hearing, and after I left that hearing, I went and I filed this motion for discovery. I said, okay, you all think that I recorded in the courtroom, but now I want your recordings. And I said, I'd like the audio and the video recordings of the courtroom at the times in question, along with all the audio and video recordings of the courthouse that show me or my person. After I did that, I then went to file what's called a motion to change venue. And the motion to change venue is a little bit of a masterpiece, I think. I really am proud of it. I'm going to bring it up so that everybody can see it. What we're looking at now is a motion for a change of venue. This is something that I typed up myself. This stuff isn't extremely hard to do. It's just intimidating when you think about it on the face. So I got the cause number up here. I got the title of the motion. And I say, comes now the respondent and asks or requests a change of venue in this matter. In support thereof states the following. Should have said, and in support thereof states the following. Number one, the allegations brought against the respondent in this cause lack for an obvious victim. 2, the allegations brought against the respondent in this cause do not claim damages. And 3, so far as damages or a victim go in this case, it seems that the court itself is the party, according to the allegations, that has allegedly been wronged. The court being the alleged victim of and judicial officer presiding over this case is a clear conflict of interests. The court being a party to this case detrimentally affects the respondent's right to a fair trial. The court indicated that certain ex parte communications had existed between the prosecutor and the court at some point before the initial hearing on this matter occurred on August 1st, 2024. And 7, the respondent has attached an affidavit of fact to supplement this motion. Right, and then I just submit it to the clerk. And that's my change of venue hearing. And then I'll read you out my affidavit that I wrote in support of this. So this is the affidavit. Cause number ahead of it, the title, supplemental affidavit of fact. And then comes now the respondent under the penalties for perjury and does state the following. That on August 1st, 2024, I was in the Greene County Superior Court on the second floor of the Greene County Courthouse. that I was a party to a rule to show cause hearing that I had been ordered to appear at not more than 1 hour prior. That while I was in the hearing, I heard the judicial officer of the court say, quote, "The state has brought it to the court's attention that Mr. Hendry didn't believe he was ordered to be here today," which, end quote, which gave me reason to believe that communication had occurred ex parte between the court and the prosecutor. And then I just, swore it and signed it. Now, this is all that ex parte means is that two parties talked. One of the parties wasn't there. Right? That they had a communication that was outside of the presence of one of the parties, right? Me. So that was why I said that. And of course, this is all fact. I mean, it is an affidavit of fact, and of course, no perjury charges have been brought against me. I filed this with the court. But my point in saying this is that there's one way that a prosecutor and a judge are supposed to communicate about a particular case. And the one way that they do that is through a motion, right? The prosecutor can file a motion and the judge can respond to the motion. But they're not allowed to just stand out in the hallway in passing and say, hey, the Craig Hendry case, I was thinking about that and he said this and that. No, they're not allowed to say that. That's totally illegal. It's a total violation of my constitutional rights to a fair trial. So that's why I included this, because of course, if I had indicated that some sort of ex parte communication had gone on between me and the judge, the prosecutor would be all over it. Now, in response to this motion, the judge recused herself from the case. She said, all right, you two have 7 days to pick a new judge, a new court to go in front of, and you choose the court. Now, me and the prosecutor got in touch after that. The prosecutor told me, this is what he told me. He said that as long as I tell him that I understand that I've been ordered not to record, that he's going to dismiss all of the charges. He said it's too expensive to go and try to do all of this stuff. So he just wanted me to basically say that I understood. Now, I want to make it very clear. I understand what they're going to do to me if I don't do exactly what they say. But I also understand the Constitution. And the Constitution grants people a right to audio and audio visually record their interactions with the government. So I made it very clear to the prosecutor, to the judge, that I think this is a complete violation of my constitutional rights. And I think that it's a complete violation of everybody else's constitutional rights. Everybody who's sitting in that courtroom, why can they not audio record? So I made that very clear to him. But ultimately, the case is dismissed. So they were really trying to put the pressure on me. They were really trying to put the pressure on people that were around me at the time. Even the people that were with me in the courtroom got questioned on August 1st when I had that hearing. So it was, the ending is a happy ending. Basically, how we got from here to there is I just took their own rules and I said, look here, I think these are the rules we need to follow. And the best thing about a court is that there's always somebody higher and they really need to decide on it. It's not one of those things like the cops can do, where you ask a cop a crazy question and they're just like, that's out of my pay grade. That's not my job. Well, it is the judge's job, and it is another judge's job. Now, that doesn't ever stop them from making terrible decisions, but it does force them to make a decision. And of course, when transparency is in their courtroom, the decisions they make are generally thought about quite a bit more than when there is no transparency, when they don't know that they're being watched. So, good news on the contempt of court front. Now, I want to make it clear, I still am dealing with 2 cause numbers in Greene County, Indiana. That's where this was out of. They've got the resisting law enforcement charge against me and the 25-foot charge. They've also got the Class B misdemeanor false informing charge, where they say I lied about a cop. They charged me with a criminal offense for that accusation. But with that being said, everybody, I think that this is a step in the right direction. I hope that we can all appreciate that this is a step in the right direction. And with that being said, Craig Hendry with the Hendry Media Group, signing off. Take care.